Okay, we should be live now.
Okay, well, I'll introduce the meeting at this time. My name's Walter Morris, a retired Superior Court judge, and I serve as a reporter for the Criminal Rules Committee, Advisory Committee on Criminal Rules, and the Advisory Committee on Rules for Electronic Filing. We also have here Emily Wetherell, Deputy Clerk of the Court, who's our WebEx mistress today. Alan Keyes, Chair of the Advisory Committee on Rules of Civil Procedure. Dennis Pearson, who is also a retired Superior Court judge, and he serves as the reporter for the Committee on Public Access to Court Records, as well as Rules of Evidence. We have Judge Timothy Tomasi, who's Chair of the Committee on Public Access to Court Records. Judge Thomas Zone, who is Chair of the Committee on Criminal Rules, and Kinvin Roth, I will say renowned, offer you that, reporter of virtually all of the advisory rules committees, presently civil rules, and I believe that's it, Kinvin.
Family, no longer family. Probate is my other.
I'm sorry for that oversight. We're here for a public hearing that is to receive public comment on a number of proposed rules. They are in a package together. They generally deal with the issue of confidentiality of juror questionnaire content submitted by prospective jurors, people from the jury duty, in answering specific biographical demographic information that is used both in deciding whether potential jurors are eligible under state law to serve or not barred under state law to serve, and also to provide the parties in a case with essential basic personal information to engage in challenges to jury service regarding either challenges for cause based on relationship to parties or issues or witnesses, or peremptory challenges, which of course are recognized under our law. And these rules are in 4 parts, I'll say. Before I get to that, I want to emphasize to anyone who's watching this hearing on the court's YouTube channel, please, please, please be advised. We're looking for you to chime in if you have anything to say or comment about the rules. Even as we're speaking here in this segment of the hearing, if you decide as we're talking, hey, wait a minute, I want to say something now, you should be seeing on your screen an email address which directs you to Emily Wetherell there. And if you were to email her indicating that you wish to speak to the rules, she'll send you immediately an invitation to join this meeting. So please have that in mind. And I trust that you will be able to see this email address on your screens from the YouTube channel. With that having been said, I want to say one other thing preliminarily, and that's if you do not yet have in hand or have not yet reviewed the text of the proposed amendments, you will also find them on the court's website. Probably the quickest way to get that right now would be to go to the website in what's called the newsroom. And right now, scrolling in the newsroom box, there's a bunch of dots that go from page to page periodically, is the press release for this hearing. If you open that press release up, you will immediately find Emily's email address to dial in, and you'll also find a link to the text of the amendments. Okay, so what are these amendments? Where do they originate? Why are we doing them? If you've read them all in detail and you're ready to go with specific questions or comments, bear with us while I go through a brief description of the origins of these amendments, purposes of them, and what they briefly say. First of all, in the origins, we've been working in various committees on this set of rules since 2015. At that time, Sarah London, one of the members of the Public Access to Court Records Committee, ran into this case, reviewed a case, Commonwealth versus Fujita, a decision of the Massachusetts Supreme Judicial Court, which dealt with the issue of post-verdict sealing of jurors, serving jurors' names and addresses And in that case, the Supreme Judicial Court reversed the trial judge's decision to seal all of that information. And while that involves one issue relating to juror identity and juror information, it prompted us to begin looking at our own rules relating to juror questionnaire confidentiality. For a while, the public access committees look at these rules remain pretty dormant. In 2017, the committee was reconstituted and took on the task of revising all of the state rules for public access to court records. This in anticipation of the court's movement to electronic case filing and case management systems. I guess I should say the other way around, case management and electronic filing systems. So we gave the better part of 2 years of fairly intense work to that set of rules, during which time these rules regarding jury confidentiality had some attention, but not a great deal. In the spring of 2019, a small ad hoc committee, we'll call it, Alan Keyes, Kinvin Roth, Terry Corsones of the Bar Association, and myself met to consider a revision of the rules. And we came up with a proposal, discussion proposal, that then made its way around the advisory committees in interest, to include the Public Access to Court Records Committee, the Civil Rules Committee, the Criminal Rules Committee. And we've come to this set of proposed amendments really for three purposes. One, to finally house in the public records rules, the access to public records rules, an exception from disclosure of content of jury questionnaires provided by prospective jurors, with the exception being that a judge could allow disclosure of the content of questionnaire for good cause. As the draft reporter's note to the proposed rules indicates, good cause would be contemplated where, for example, an academic study were in progress as to juror compositions with perhaps redacted information, meaning redacted identities, but full access to the content. Or another aspect or example of good cause would be to permit counsel in a case where there was more than just issue or challenge with regard to the jurors present for voir dire, but counsel wished to engage in what we call a Batson challenge, or under JEB versus Alabama, a gender-based discriminatory claim, and wished to see the whole trail of the composition of the jury going all the way back to their summoning. So there was an exception for good cause. So the first part of it is to house confidentiality rules in one place, primarily the public access rules. The second purpose of this, in our deliberation, to provide more clarity to counsel and parties in specific cases as to the scope of their access to juror questionnaire content, as well as their obligations in turn in terms of preserving confidentiality and being able to fully use and properly use, as should be the case, juror questionnaire content for full and fair voir dire and full and fair challenge to any juror's service. Thirdly, there is an inconsistency that was found between the rules for juror summoning and qualification, initial summoning and qualification, and these rules are often overlooked, but they're actually housed in the back of the probate and administrative orders volume of our statutes. The court administrator suggests, or is the promulgator, I'll say, of those amendments regarding jury summoning, qualification, and confidentiality, subject to the court's decision with regard to the text of the rules to be adopted. The court is still the promulgator. The court administrator is in charge of the jury qualification and confidentiality amendments that I'm talking about. So there's a conflict between provisions of those rules, Rule 4 and Rule 10, of the jury qualification and confidentiality rules, and the provisions of two identical to themselves criminal and civil rules on access to jury questionnaire content by parties in civil or criminal cases. Those rules, Rule 24 of the criminal rules and 47 of the civil rules, both provided for a description of access to juror questionnaire content that was actually contrary, if not in full and substantial part, to the rules of the jury qualification 4 and 10. Be very specific. Rules 4 and 10. Excuse me while I look for my sheets, which, as usual, they go away. Rules 4 and 10, if you read them together, say, rules we're talking, all information other than an individual's address and date of birth shall be public, including the name of the individual and town of residence. So the name other than individual's address and date of birth. Rule 10 goes on to add telephone number and mileage to the court are also not available. Otherwise, all information is available. If you read those rules, juror by name, Walter Morris, his questionnaire content following here with all of my answers about biography, family, convictions, all the rest, are accessible. If you look at the provisions of Rules 24 and 47, they provide that all juror questionnaire information is accessible to the public after name and address of the juror is redacted. So you can't have both. So what we're doing here is taking the reference to public access in Criminal Rule 24 and Civil Rule 47 and basically housing all of that in the exception in the public access to court records rule. And that proposed rule is proposed public access rule 6B19, as your draft shows, the published draft. And apart from the reconciliation that occurs there are in Rule 10 primarily of the juror qualification rule. If you're looking at the draft, you'll see that Rule 10 has two sections, one addressing public access, the other addressing access by parties and their attorneys. And in terms of parties and attorneys, of course, parties and attorneys have full access to juror questionnaire content. There's one exception in the amended rule, and it's reflected in the public access rule and also in Rule 10 as amended. And that is where a juror has submitted what we call supplemental information relating to service, seeking excuse from service based on a mental or physical condition that renders them unable to perform the duties of a juror. That information, if a juror has been excused based upon that reason, is not accessible either to the public or to the parties or lawyers in a case. One might ask, well, why is that the case if we have a jury that we're trying to fairly impanel a fair cross-section and have a just decision made? For such jurors who have already been excused from the panel, those folks are never going to appear in a courtroom subject to voir dire, subject to challenge as to service, or subject to service. As to anybody who is reporting in a courtroom as part of a prospective jury panel subject to voir dire, of course the parties and lawyers would have a right to access to confidential information for purposes of their decision making as to a fair and impartial jury. Of course they do. But if that person's already been excused by the court for cause, and in these times, as we've looked at these rules, we discern an even greater need for that preservation because there will be many more jurors, perhaps, who, by reason of COVID, as jury trials resume, will have either a family member or a contact who's been exposed, have been diagnosed with COVID themselves, or as in all days and in all ways in jury composition, have sensitive, privileged healthcare information that would obviously excuse them from service without having to come to court for voir dire. And if the juror has already been excused, there's no reason for the disclosure of that information. So the bottom line here is, as to parties and lawyers, essentially no changes to essential access to know about, to fully question those people who could become the judges of fact in a case. That remains the case, no impact there. So basically, those are the changes in the rules that you see proposed here. In the late stages of circulation of these proposed rules, prior to publication, in going through the Civil Rules Committee, two of the members of the Civil Rules Committee provided comments about what they would like to see or suggest in the proposed rules. In the one case, the comments were right on the money and fairly readily addressed. If we have an exception from public access generally to content the juror questionnaire, does that inhibit the lawyer in the development of their case, in the examination of the prospective jurors, from even mentioning questionnaire content in the courtroom in voir dire? And of course, no. The proceedings in open court in voir dire are classically and unquestionably public, part of the constitutional heritage of an open and fair trial. So the rule, of course, does not prohibit that. And you see the language in Rule 6B-19, as well as in 10, that accepts that type of reference in the court proceeding to juror questionnaire content, just to make it clear, if there's any doubt, the counsel have full right to examine jurors in open court or even in individual and segregated voir dire as to questionnaire content. There's one other thing that's worth mentioning about the group of rules here, and that is that the rules do not purport, on the latter subject that was being mentioned, to do anything at all about public access to proceedings. Of course, any closure of any part of a criminal case is subject to the so-called press enterprise tests, press enterprise 1 and 2. I think it's first, I don't remember the exact name of the respondent jurisdiction, but it's press enterprise line of cases, which established a very familiar balancing test and restriction upon access, public access to traditionally open public proceedings without a serious engagement by the judge in a calculus of the risks sought to be prevented or the harm sought to be prevented versus the public interest in the open proceeding. And you'll see press enterprise referenced in the reporter's notes to the rules to provide indication as well that we acknowledge this promulgation. The court would, reporter's notes are advisory. The advisory notes would clearly note that public access to open court proceedings is not what we're addressing here. It's preservation of reasonable expectations of confidentiality on the part of jurors who are summoned to serve. One other thing to be said about that policy issue of preservation of confidence is there are many jurisdictions that bar as to access to the public content of jury questionnaire content. And we have, again, is seeing the wisdom of doing that here, provided for a good cause exception in any case, such that the judge could decide in that balancing of interests that content of jury questionnaires is to be disclosed publicly. The reporter's note as well considers the interests of media as from time to time wish to examine the demographics of a particular jury as being in that category of good cause that a judge might consider for disclosure with redaction of names, so that the body of the jury can be examined, who's on it, what are their characteristics, without assigning that data or information to a particular juror. An underlying concern that has been faced by some state courts as to jury questionnaire content access is movement to electronic case record systems. And it's all about data. And a concern is that as we ask jurors to reveal personal and in some instances very highly sensitive personal data about themselves, the question of security of that and reasonable measures to prohibit or restrict or at least reduce such things as data mining and improper use of jury data is at work here in the policy to be looked at. So that's what I would say at this point. We could together as a group, and anyone else who is watching the hearing could also certainly weigh in at great length about various dynamics of jury proceedings. To kind of sum it up, housing a general exception from public access to juror questionnaire content in the public access rules in context with a group of rules dealing with public access to court records, curing apparent inconsistency between the juror qualification rules and the criminal and civil procedural rules, and third, bringing some further clarification to parties and attorneys in cases about rights of access and obligation with regard to the content that they're viewing. There are two issues that we remain to have to examine, and some of you watching may be aware of these as well. One is the extent to which electronic access versus hard copy access to juror questionnaires should be provided. And the other is duplication of juror questionnaires provided to counsel, primarily within a multi-lawyer office. So we're aware of both of those issues, and be assured that we will be addressing them in the next, I'll call it the final round after public comment before any recommendation to the Supreme Court. I don't know how many minutes I've spoken. Forgive me if that's too long in anyone's view, listening or on the panel presently. But I think at this juncture, it's time to ask my colleagues from the rules committees if there's any other point that they would like to see mentioned before we invite any further comments from those who are watching.
Walter, can you hear me?
Yes, thank you.
One of my committee members did comment on the last issue you mentioned of whether a law firm could circulate the juror questionnaires in-house.
Right.
And I saw the rule provided an exception for preparation for voir dire, and I thought that encompassed it, but would hope there'd be a report or note to clarify circulation within the law firm would be an example of preparation. But you're saying that your committee hasn't fully settled on that question?
Thanks for your question, Ellen, and it's a good one to bring up. Why wasn't it just incorporated into the draft everyone sees for publication? That was one issue that we just did not land on. My own take is that it makes complete good sense in a multi-lawyer firm or in a firm where there's a lawyer, paralegal, or lawyer or office manager. We know how law firms function. The office manager or the paralegal helps the lawyer do their work. But the point being, to have questionnaires be able to be copied and duplicated and shared among many or a number of law firm participants, it only makes good sense. It was not added to the draft as published because, again, I think in fairness, the committees had not, to my knowledge, specifically considered that issue. The other issue brought forward by one of the other similar rules members about, does this mean we're restricted in reference to content of questionnaires, seemed to be such an obvious resolution to that was included in the draft as you see it. So yes, is the answer to will it be duplication allowed? Ultimately, like all of the content of these rules, proposes for the Supreme Court to decide. But I would imagine that in each of the rules committees considering the proposal, duplication within a law firm for the purposes of their work and jury selection is a logical one that should be permitted. Thank you.
If I might chime in on that, looking at the draft in 10B1, we have must not duplicate, and I think it's the implication of that particular prohibition on the in-house duplication that Alan's the comment Alan has reported on addresses.
Right. So that you put your finger right on the fix, so to speak, to this, which is to amend 10B1 to either provide an express exception or define what duplicate is for purposes of application of the rule. That particular language, I can tell you, came from another jurisdiction's formulation of use of questionnaire content. And I believe Terry Corsone's brought that to our ad hoc subcommittee. It's been in there since the spring of 19. But again, it seems like an oversight that it has an obvious cure for what seems to be plainly reasonable to allow duplication in a law firm.
Judge Morris, I just see someone has joined by telephone, and I'm not sure who that is or if it's someone that wanted to offer some comment.
Okay, whoever it is, can you identify yourself and please be heard? We want you to be heard.
So, Emily, if you're talking about me, this is Patricia Gable, the court administrator, and I don't have any comment at this time.
Okay. All right. So, as I've indicated, Pat is we'll call it the proponent as court administrator of those jury qualification rules. So, if there's no further comment from I'll call it the panel participants, who again are the chairs and reporters of the procedural committees in interest, I propose that in the interest of assuring that anybody who wishes to be heard, that I remain on the line and participating, that any of the others who wish to not continue to participate in the WebEx, meaning our panel members whose faces are showing, feel free to disengage, or that I will wait 5 minutes at this juncture in case anyone who's watching via the YouTube channel still wishes to connect via an email to Emily. Others can depart the screen, or we can all remain on the screen if Emily will time us for 5 minutes, and then we'll adjourn. If that's okay.
I'm happy to put my faith in Emily's stopwatch.
Okay. All right. So we'll run 5 minutes here.
And maybe just for the record, I haven't received any further inquiries for participation.
All right. While the clock is running here, I can say when we convened a public hearing on the 2019 rules for public access amendments, we were at the Pavilion Auditorium, of course, way pre-social distancing. In the published hearing, this was one to which, because of the breadth of the revisions, we had asked that the Supreme Court actually join the meeting. All of the justices came to the meeting. Some of you were at the meeting, and we had a similar advanced presentation, and there was no member of the public who wished to be heard. There was one person present, Andy Stone, employee of CAO, who pointed out a typographical error in our draft. And that was nice, but we waited 15 minutes because of the issue of, physically getting there to join the meeting. And here, since we're all electronically connected, the shorter period of time, it seems, will work. I guess one other thing to report for the record while the clock is running is the advance preparation to this hearing. The proposals of amendment were published on September 16th for comment. And by the way, the comment period is still running. Let me not forget to say that. Whether you're watching and don't choose to join the meeting itself, written comments are still most welcome, and we want to have written comments, critical comment, through November 16th. So you've got quite a bit of time yet to submit written comments, and please do, please do. I can tell you, and everyone on the screen here can tell you, that when there are written comments submitted in response to a rules proposal, the committees take those very seriously. Each one is reviewed, each one is discussed and considered by the committee. And often those comments are incorporated into changes that improve our rules promulgation. So please, whether you want to participate in video or not, make sure you send us written comments to inform us by November 16th. There was a press release given. It's still on the court's website on September 28th. A notice of hearing was printed in 5 of the regional newspapers in the period from October 1st through 3rd. And then there were memos provided to the bar of the proposed rules and the public hearing itself and how to access on both October 7th and just again on Monday, October 26th by the court administrator, by the court. So we've done as best we feel we can to invite participation. We are public servants as part of the judiciary and are not shy of receipt of, we call it criticism, or let's put it this way, any comment that would serve to improve our work. So please, that's all I'll say about that. We're not offended. We welcome comment and feel it's helpful to the effort to provide good rules. And I guess that's all I will say at this point. Returning to any of the facial participants, is there anything to be said? Yeah. Okay.
Emily, can you tell whether anybody actually tuned in or not, or is that something they can't do?
Yeah, I can tell. It looks like there's about 12 viewers of the YouTube.
That's great. You don't need to out yourselves. I will just say again, of the 12, tell your friends, tell your colleagues, please. Help us out with a close look at these rules and comment about what you think about them.
Even if people aren't watching live, the recording will stay up on the court's YouTube page. So
Right.
People could also be directed there to watch it after it's over. By my clock, your 5-minute window there has closed now.
Okay. So thanks to all who the chairs and reporters who've joined us. Thanks to all of you who are watching this and who will watch this hopefully in the period to come. Again, November 16th. The comment period does not close until then. Please submit written comments. You can find my email address. It's walter.morris@vermont.gov. On the proposed rule notice, any members' notices to the bar, and the publications made of today's hearing. Please comment. Thank you. Okay, we'll adjourn this hearing, and thanks to you, Emily, for the arrangements to do this. Okay.
Absolutely. Nice to see all of you.
Okay,
Yeah.
thanks, Walter. Good job.
Thank you, Judge Morris. Thank you, Emily.
Absolutely.
See you tomorrow, Alan.
Take care.